the arraignment, your case will probably be scheduled for a pretrial hearing. Today we are going to take you out of the crowded courtroom and discuss why your case keeps getting passed from pretrial hearing to pretrial hearing. Okay, so you've had your arraignment. The judge passed the case to a pretrial hearing or a status hearing. So now what? This is where the work really begins. It is what is happening between the pretrial hearings that is important, not necessarily what's happening at the pretrial hearing. But it may be very frustrating for you because you may not see exactly what is being done behind the scenes. Between arraignment and trial, your attorney is obtaining discovery, which is the evidence the state intends to use against you. They're negotiating with the prosecutor, they're researching legal motions, they're meeting with you to discuss the case, meeting with potential witnesses or scheduling depositions, and otherwise preparing the case for trial. So what happens at a pretrial hearing? Pretrial hearings are the judge's opportunity to keep the lawyers on schedule. It's an opportunity for the judge to get the prosecutor and the defense attorney in one room, to make sure the case is moving along, and to deal with any pretrial issues there may be. For example, the judge is going to want to know if a witness didn't show up for a deposition, or if the lawyers are arguing over whether the prosecutor should turn over specific evidence, or if the lawyers plan on filing motions in the future. And the judge can set deadlines for the attorneys to accomplish certain tasks, like motion deadlines or deposition deadlines. At pretrial hearings, the judge wants to know what the attorneys have done on the case since the last pretrial hearing. And so should you. You should ask what the attorney has done in between each of those court hearings. The attorney may be waiting on a state offer or additional discovery, or may have depositions scheduled, or may be researching a legal issue. You should make sure you stay in the loop and have your attorney explain what has happened between pretrial hearings. If you don't understand the process, you won't know whether your attorney is doing a good job. Your attorney should be able to explain where they are in that process, what they've done, and what they intend to do in the future. And they should be able to give you an estimated timetable for when the case will end. Every case is different, but the general rule is that the more serious or complicated the case, the longer it will usually take to resolve or to get to trial. A serious misdemeanor like a DUI or domestic battery can take up to a year to resolve if there are legal motion hearings and a trial and a lot of other issues that come up. Typically, it will be resolved within 6 months. A felony will usually be resolved within a year, but some more serious or complicated felonies can take several years to resolve. These are very general estimates, but give you some idea of the typical lifespan of a criminal case. Most judges will waive your appearance so you don't have to come to court for each pretrial hearing. Make sure you know whether your judge requires your appearance for each and every court appearance, and make sure you keep up to date with your court dates with your attorney. If your attorney and the prosecutor have not resolved the case, and once the discovery and investigation is complete, the judge will schedule your case for trial.